All right. We're almost there. Almost there. Just 2 more sessions and then we're all done. And I speak for all of us. No, I'm kidding. So I'm also recording on Zoom because Nolwenn isn't here and seeing my track record, I just want to cover my bases. I've also recorded that little video that I said I would that was missing with the examples of the questions. I think it's the same examples I gave in class. If it's not the case, those of you that were in class, you get something different, but I think I picked the same ones. Nolwenn has also opened a forum, which you'll find at the beginning of the Moodle page, where you can start if you have any questions regarding the exam, you can start writing them then, and then we'll address them. Again, some of you asked me to do a quick Zoom session in January, avoiding the 14, if I'm not mistaken, which is when you have arbitration. Great, so we'll do another day, which is not that. And then today I probably have been overly ambitious because this is where I work on. Most of my work is on the interface between economic law and other things, including environment and climate change. We may not finish today everything that I want to cover, but that's okay. We'll continue next week, and I will adjust then the material for next week so that we manage to finish, of course, in time. I want to start by telling you 2 little stories. Now, the first one, you don't have to, remember these dates. It's just for you to get a sense of the topic of today. So the 31st of January 2020, this is the date when the Supreme Court of the Netherlands delivered a very famous judgment called, in the case Urgenda, with the Netherlands. Now, this was a case that had been brought to the Hague District Court back in 2015 by Urgenda, the Urgenda Foundation, which is an environmental Dutch NGO, and 900 Dutch citizens against the government of the Netherlands. And the main argument that the claimants had was that the Netherlands was not doing enough in the fight against climate change. They had not been ambitious enough in their targets when it comes to emission reductions. Now, we'll talk about it later in a second. I don't know how familiar you all are with the Paris Agreement. I think everybody should be a little bit familiar with it, but countries have to report something that is called NDCs, Nationally Determined Contribution. We'll talk about those later, but so every country can choose the target of their emission reductions and what measures to adopt to achieve that target. Now, the Netherlands had set as target a reduction of their emissions of 17% by 2030 compared to 1990 levels. And the claimants were arguing that this target, 17% of reduction, was not enough, considering how severe and urgent climate change is, considering the capacity of a country like the Netherlands, and considering the global temperature target for all countries of 2 degrees, that is set in the Paris Agreement, 17% wasn't sufficiently ambitious. And the court said it's true. The Netherlands, you're not being ambitious enough, you need to do more. So you need to reduce at least by 25%. So they ordered the government to be more ambitious, up their target, 25%, and so adopt new measures to be able to meet that target. And the government did. They already had some programs in place for emission reduction, but of course they added a few things. Now we fast forward 1 year, In February 2021, the Netherlands is again brought to court, this time not by some concerned citizens, but by a foreign investor, RWE, a German corporation that was very upset. It was very upset because the Netherlands, as part of their climate change package, they had decided to shut down some coal-fired power plant, and they had decided to accelerate the timeline, and RWE was upset because they felt that their rights had been violated as a foreign investor. This was not the only company. 2024, ExxonMobil, this time not because of the decision of the government to shut down coal-fired power plants, but because of the decision to shut down gas production and to accelerate the timeline to shut down gas production in some provinces, including Groningen, which is where ExxonMobil was operating. Both companies brought the dispute under the Energy Charter Treaty, claiming violation of a number of their rights. So as you see, you have the same country that is trying to do something for climate change mitigation, so adopting measures. The energy sector is at the heart of climate change as a problem and climate change mitigation efforts. So it's not surprising that a country like the Netherlands, but many others as well, would reform that specific sector, trying to transition away from fossil fuels all the way to renewable energy. But by doing so, they upset foreign investors that had gone in the Netherlands and were operating in the gas sector or the coal sector, thinking that the framework would be stable, that things would be great for them. And when things are not great, they sue. First example. The second one, we go a little bit back in time, 2009, and we go to Canada, province of Ontario. In 2009, the province of Ontario, this is upsetting me, had introduced a feed-in tariff scheme, a feed-in tariff program. Now, this was part of a much broader strategy in Ontario and other provinces in Canada to diversify their energy supply mix, and in particular to increase the share of renewable energy in the national electricity grid. So the feed-in tariff, basically, it's a program. If you're a generator of electricity, you can apply, and if you win a contract under this program, you get a very long-term contract, 20 years, 40 years. It's very good. You provide electricity at a price that, in this case, is above market. So, you have a long-term contract. You know that for 20, 40 years, you'll be providing electricity to the national grid at an above market price. Well, that's pretty cool. There were some conditions, even just to be eligible for this program. The first one is that you had to show that you were sourcing electricity from these sources. And this, again, because the overall idea is to facilitate the renewable energy transition, increase the share of renewable energy in the electricity production. But then there was this other condition, tricky one, a local content requirement. So in order to qualify, to be eligible, you had to show that your electricity was coming from one of these, and you also had to prove local content requirement, meaning that you were sourcing, so you were buying, basically, a certain percentage of your generation equipment locally. And the percentage, these are just some examples, quite high. So those are the two conditions. Now, the European Union and Japan, big exporters of generation equipment to Canada. Now, you are a generator, you want to get one of these contracts. What do? Do you keep buying your generation equipment from the EU and Japan, and then you risk not qualifying for this? Or you say, you know what, I'm going to buy local so I can qualify for this super cool feed-in tariff. You buy local, right? So the EU and Japan were upset because this would have had an impact on their trade, not of electricity, but of inputs. And so in 2011, they bring a dispute to the WTO, arguing that this was a subsidy. And not only was a subsidy, it was a prohibited subsidy, because it was local content requirement, contingent on local content. So again, you have a country, a province, but let's say a country that is doing something with the idea of reducing emissions, moving away from fossil fuels, increasing the use of renewable energy. And once again, you get sued because your measure has an impact on trade. So this is a little bit what we're going to talk about today. Now, there is a clear tension between, on the one hand, again, countries' efforts in the context of climate change mitigation. Countries are adopting a whole bunch of different measures to reduce their emissions, but they have this whole legal framework that they need to take into account: trade law, investment law. In particular, when it comes to investment, we will see this. There is a real risk of what we call regulatory chill. Regulatory chill because countries are literally frozen. They are afraid of regulating in the public interest. For example, for climate change mitigation, because they fear disputes brought by investors. And even, in this case, and we will see, but this measure, the feed-in tariff that Ontario introduced, it triggered a dispute at the WTO, but it also triggered an investment dispute by an American investor that was upset because they weren't getting the contract. So you always have to be very careful. You are acting to mitigate climate change, great, but what does this mean from an investment law perspective? What does it mean from a trade law perspective? So this is kind of to give you a sense of why it matters to talk about these issues. Now, before we get into we get back to these cases and we get into really the tensions between trade, investment, and climate commitments, what are climate obligations of states? So what does climate law tell states that they have to do? Does international climate law tell states to subsidize renewable energy or to phase out fossil fuels? I think most of you haven't taken international environmental law, right? No, I think there's maybe a couple. Okay, this is going to be a 10-minute crash course on international climate law. If you like it, come back for the spring for the course that I give with Professor McCann-Bang on international environmental law. But just so that you get a sense of what is the legal framework in climate law for states, and then we see what that means for trade and investment. So first of all, think that when it comes to states cooperating to protect the environment or to protect the climate system, state cooperation started way later, much after states were already cooperating on investment and trade. They have been bilaterally cooperating on investment and trade already since the 18th century with those treaties of friendship and navigation. But, for example, multilateral trade already in the 40s, right, with the GATT, and investment as well. International cooperation and international law on the environment starts in the 1970s, so much later. Climate, 1990s. So it's way more recent, which has an impact because all of this cooperation happened not in a vacuum, but in a system that was already working of rules, trade rules, investment rules that were already there. Now, one of the key dates when it comes to international cooperation on climate is 1988. Creation of the IPCC, the Intergovernmental Panel on Climate Change. That is the kind of scientific body. We have a few professors at the University of Geneva that actually are lead authors of some of these reports of the IPCC. IPCC collects, studies the science, and provides recommendations for policymakers. And a lot of the law, both domestic and international, on climate is based on the work of the IPCC. IPCC has developed 6 assessment reports every 5 years, more or less. And the first one was the one that kind of, triggered the first negotiations on climate change. 1988 was also the year of the first time the UN General Assembly talked about climate change. The very first resolution of the General Assembly, 4353, is from 1988 on climate change. So really, really important date, but as you see, it's much later, right? We already had 40 years of GATT by the time we get here. Next key date is 1992. On the basis of the first assessment report of the IPCC that was published in 1990, countries come together under the United Nations, and we have the very first international law instrument on climate change, which is the United Nations Framework Convention on Climate Change from 1992, which is still valid, which is still kind of the umbrella framework convention. Now, this is a terminology, again, this is very, very different from trade or investment law. In environmental law, we have a lot of these framework conventions. They're not really treaties because there's nothing binding in them. They're really just frameworks. They set out the objectives, the principles, maybe some institutions. They set the stage for future binding instruments. And again, when it comes to environmental protection and climate, we use this mechanism a lot because it's just very hard to already start with binding obligations. Imagine here, again, we start in 1988 to discuss that climate change is even a thing. Countries would have never agreed just a few years later to reduce their emissions. So they need time. So first they came up with this framework convention. And then on the basis of this convention, they have adopted treaties, the Kyoto Protocol, for example, the Paris Agreement, always under this umbrella convention. Just a couple of things that I want to show you about this convention. First of all, this is just the beginning of the preamble. I just want to highlight a couple of things. So first of all here, the third preambular paragraph, noting that the largest share of historical and current global emissions of greenhouse gases has originated in developed countries. This is a very important statement. Everything that has happened in international climate cooperation, relations, law, is based on this acknowledgement by developed countries that they are responsible historically and currently. They have accepted responsibility, historical and current. This is why even today you have a lot of developing countries that are emitting a lot, but that point to this and say, well, yes, okay, but look, it's the developed countries actually that have historical and current responsibility. So this is quite important, and how this has then been translated has been in a very important principle, which is this one: common but differentiated responsibilities and respective capabilities. This is one of the key principles in climate law. We call it CBDR-RC. Common but differentiated responsibilities and respective capabilities. The idea that because countries do not have the same responsibility, historical, current, they haven't contributed in the same way to the problem, and because they do not have the same capacity to deal with the problem, we can't expect the same behavior. So we can't expect that we should impose the same obligations on the United States or on Malawi or on Antigua and Barbuda. We can't. Different contributions, different capacity. This is a crucial principle. Article 2, you have the objective of the Framework Convention, which is extremely vague. Now, in a nutshell, what it tells you is that the ultimate objective is the stabilization of greenhouse gas concentrations in the atmosphere at a level that would prevent dangerous anthropogenic interference with the climate system. Stabilization of greenhouse gas concentrations in the atmosphere. This is good. This they got it from the IPCC. More emissions means more concentration of greenhouse gases in the atmosphere, which means more retention of energy, which means temperatures rise. So we need to work on that concentration. But the stabilization has to happen at a level that would prevent dangerous anthropogenic interference with the climate system. So we understand that there is a certain point where it could become dangerous, but we don't know which one it is. So it tells you, yes, you need to stabilize so that it doesn't become dangerous, so to that specific level, but what is that level? So it's a very broad and vague objective, which makes sense because it's a framework convention. Framework conventions often have vague objectives, but most importantly, this is 1992. If you read the IPCC report from 1990, there's not a lot. There's a lot of uncertainty. The science has evolved over the years. Now the science is much more certain, and now we have clearer objectives. But that's the situation in 1992. That's all. And then, so the idea is to stabilize the concentration. Ideally, in order to do so, we would have to ask countries to reduce emissions. And that's when CBDRRC, Common but Differentiated Responsibilities and Respective Capabilities, comes in. The system that the UNFCCC has created is a system where states are divided in two groups. The first group, we call them Annex 1 countries because they are listed in Annex 1 to the convention. It has OECD countries and countries with economies in transition. Everyone else that is not in this annex, we call them, not very creatively, non-Annex 1 countries. They're developing countries. Why this distinction? Because it allows us to impose CBDR. We can differentiate responsibilities. The idea is those countries that are in Annex 1 are those that are more responsible and are those that are more capable. So they're going to have to reduce emissions. Countries not in Annex 1 don't have any obligation to reduce emissions. None. This is the system created in 1992. Then the Framework Convention was followed by the Kyoto Protocol, 1997, entered into force in 2005. The Kyoto Protocol built on this distinction and indicated for each country in Annex 1 targets, how much they had to reduce emissions. Germany, you need to reduce emissions by this much. Spain, by this much, and so on and so forth. So the target, in terms of the percentage of emission reduction, was set in the Kyoto Protocol. But it was there only for OECD countries and countries with economies in transition. Actually, only those that ratified the Kyoto Protocol, so not the US, for example. The US never ratified the Kyoto Protocol. They were very present in the negotiations, but then they didn't ratify. Now, one of the reasons why they didn't ratify, they were not entirely wrong, not in not ratifying, but in what one of their concerns was. And one of their concerns was that, I'm sorry, but what about all those developing countries that have become high-emitting countries? What about China? What about India? What about Brazil? What about Mexico? They are never going to have emission reduction targets. This was a very rigid distinction between the two, the Annex 1 and the non-Annex 1. You couldn't graduate and move to another. So this would mean that under this system, you would have a lot of countries that, because developing, were not in Annex 1, and they would never have to reduce their emissions. So we lost the United States, which is a shame because it's a big emitter. So you don't have a country like the United States accepting targets. Well, not great. This is why the Paris Agreement that we'll see in a second has changed completely the approach, which is the approach that we have today. But one last point that I want to show you of the UNFCCC is in the principles, this part, and I want you to have a look at it, in particular the second sentence, and I want you to tell me what it reminds you of. The second sentence, starting from measures, should remind you of something, hopefully. Yes. It's the GATT, but it's not the preamble of the GATT, this. It's something else, but it's in the GATT, so you're narrowing down your search.
The most FMN and measures?
Yes. Article 20, chapeau. Excellent. Chapeau of Article 20. So your exception clause, how you justify a measure that is in violation, you have, it's not exactly, but it tells you that the measure should not be implemented in a manner that would constitute a means of arbitrary or unjustifiable discrimination. Come on, this is what where shrimp lost, where the US lost. Or a disguised restriction on international trade. I wanted to signal this because, the chapeau of GATT Article 20 is from the 1940s, right? This is a framework convention from 1992. By the way, same years as the Uruguay round. But there is a reference to, it's a clear, explicit reference to the GATT. So there is the understanding that countries might want to adopt trade measures for climate purposes, because trade measures are very effective for environmental purposes. Countries have been using them for, decades. But there is a reference to the text of the GATT. So this gives us a sense that the idea is that we should have mutual supportiveness, which we should have harmony between, climate law and trade law. The idea is not to create a system that is in tension with trade law. And you have a direct reference, meaning, yes, of course you can adopt trade measures, but be careful, there is this that still applies. So this is quite interesting to have. Now, going back to how the system works, as we said, Kyoto Protocol strengthens the distinction, imposes binding targets in terms of emission reduction for OECD countries and countries with economies in transition, again, those that have ratified the protocol. But this fact that a lot of high-emitting developing countries don't have any obligations become an issue, not just for the United States, for other developed countries. And also for other developing smaller countries that are saying, I'm sorry, but I'm not the same as China, I'm not the same as India. We contribute so much less. We'll talk about the advisory opinion of the ICJ if we have time at the end of the session. I was part of the team that represented Antigua and Barbuda before those proceedings, and we had a lot of conversations with them. They emit 0.003%, and they were in the same basket as China. So you have discontent, yes, from developed countries, but also from, from small island developing states, LDCs, and so on and so forth. And it's not just China. I just used as an example. There's a lot of countries that are now emitting a lot, although they still self-identify as developing. At the same time, the IPCC is coming up with other reports and is telling us, guys, the situation is getting very, very problematic. We need to do more. We can't just have a handful of countries reducing emissions. We need global cuts. Everybody has to contribute. Everybody has to do something. So we get to Paris, 2015, COP21 in Paris. Big success, the Paris Agreement, which decided to adopt a completely different approach. Because basically you had two choices. You could either say, okay, I want hard binding targets, but then you're going to have very few countries that are going to accept them. Or I want as many countries as possible, but then I have to be soft. So how can I design an agreement where everybody joins, so that everybody joins, so that everybody's okay in accepting to reduce emissions? I make it so that everybody has to reduce emissions, but each country can choose how much. You can choose. You're free. You can choose your target. I'm not going to tell you how much, how ambitious you have to be. That's the approach that has been taken in Paris. And we could talk for hours as to which one is best, which one is more efficient. Now, Article 2 gives you the objective. We just focus on these parts that are on mitigation. And you can see it's a lot more sophisticated than the UNFCCC from 1992. The UNFCCC was telling us simply stabilize concentration of greenhouse gases at a level that is not dangerous, interference, and so on and so forth. Here it tells us, no, we have actual figures. Here they don't focus so much on the concentration, but on the temperature, but they're linked. So we need to hold the increase in global temperature to well below 2 degrees, but trying to keep it under 1.5. So we have 2 targets. Why 2 targets? There was a lot of discussion. Many countries, developed countries, wanted a 2 degree because they felt that it was achievable. It was a more realistic target. And they felt that 1.5 was too idealistic. And if you have a target, an objective that is too idealistic, the whole treaty kind of loses its strength. And then you had small island developing states, low-lying coastal states that were pushing for 1.5, because for them, a 0.5 difference can mean we have a territory in 20 years or not. So the compromise was this, which, what does well below mean? Either it's below or it's not, right? Now we will see, but again, it's been confirmed by the IPCC, and the ICJ in its advisory opinion this summer has told us, forget about 2, we need to think of 1.5. We are already beyond it, but in terms of how we structure our own individual targets, we need to try and aim for 1.5. So this is a global target, global target, not for individual countries. All countries together need to aim at this. And here you have again CBDRRC. This has to be done in line with common but differentiated responsibilities and respective capabilities. So again, this principle. But Paris changes completely the approach. They destroy the distinction between Annex 1 and non-Annex 1. They say everybody has to contribute. Everybody. Every country has to reduce emissions. But you choose how ambitious you want to be. And this is what we call nationally determined contributions, or NDCs. How much do you want to contribute? Nationally determined contribution. All parties are to undertake and communicate ambitious efforts. So what countries have to do under Paris is every 5 years communicate to the Secretariat of the UNFCCC their NDCs. What is their target? What are they doing to achieve it? That's it. And it has to be a progression over time. It has to be a progression over time, which means that every 5 years you can't become less ambitious. You need to become more ambitious. If you set a target that is not ambitious enough, what could happen to you? Urgenda. You can be sued in your own courts because you're not being ambitious enough. Because that's it's your law, it's your domestic law that determines the ambition. The Paris Agreement doesn't tell you how ambitious you have to be. Again, keep this in mind. Things may be changing because of the advisory opinion. The advisory opinion gives us a different reading, but we're going to get to that later. But for now, think about this. Paris leaves countries free to choose their target. Do I want to reduce my emissions by 2%, by 20%, by 70%? It's up to me. And how am I going to achieve that target? Do I want to introduce a carbon tax? Do I want to introduce regulations? Do I want to subsidize? Which sector do I want to focus on? It's up to regulatory sovereignty of the state. States are free. So if you think about the examples I gave you at the very beginning, the Netherlands deciding to shut down gas production or coal-fired power plants, that's the Netherlands' choice. International law is not telling the Netherlands to do that. That's how the government has chosen to meet its own target. Ontario introduces a subsidy for renewable energy producers. That's the choice of the province of Ontario. It doesn't come from international law. It doesn't come from the Paris Agreement. And this means that whenever you have a conflict or a tension, the tension will not be, or the conflict will not be between a provision in the WTO agreement or a provision in an investment treaty and international climate law. But the tension, the conflict will be between a trade agreement or an investment agreement and your own domestic measures. So the whole question boils down to, so it's not an issue of conflict of norms, it's an issue of to what extent is your domestic measure consistent with the international law framework that you have accepted, investment law and trade law. And this is the first thing that we're going to look at. What does it mean to operate within the existing framework? Whenever countries want to regulate or legislate for the climate, what do they have to think about? And then we're going to move to an additional question, which is, okay, countries have to move within the framework that exists, but is this framework adequate? Trade law, investment law predate climate change. So they were not designed with climate change in mind. Are these rules adequate for the climate crisis, or do we need new rules? Can we just rely on an evolutionary interpretation of the panels, maybe one day a second appellate body, and arbitral tribunals? Or do we need new rules that reflect society as it is today, which is facing a climate crisis? So these are the 2 points that we're gonna look at. Let's start with this first one. We start with it, and then we move to the second one. So operating within the existing framework, this is really crucial. And again, if any of you decide to work in this space at all, a lot of what governments want is this. How do I design a measure that is not going to trigger a dispute in investment, that it's not going to create problems from a WTO law perspective? So this is a lot of what governments need, because they have to do something for climate change. Again, otherwise they get sued in their own domestic courts, and they have taken some commitments under Paris, but they also don't want to, go to the WTO panels or, go to ICSID every other day. So the first thing to keep in mind is that you need to keep in mind the overall framework, not just trade, not just investment, because the very same measure can trigger both, like a dispute under both trade and investment law. And again, this is a good example. It's not the only example. There's other cases where we have seen both an investment and a trade dispute against the same measure. So our feed-in tariff introduced by Ontario has triggered both a trade dispute, Canada FIT, and an investment dispute. So the trade dispute was brought by the EU and Japan under the claiming a violation of the agreement on subsidies, but also the GATT, the TRIM, so a bunch of different agreements, in particular because of the local content requirement of the measure. And instead, the investment dispute was brought by MESA, that is a US company under NAFTA, that had applied several times and had never been awarded a contract. And so they claimed that they were being discriminated against and treated unfairly and unequitably under the investment chapter in NAFTA. So again, you have the very same measure that a country has adopted allegedly for climate purposes that has created problems under both trade and and investment law. Now, is the problem trade law and investment law? So do they really constrain countries' ability to legislate for, the climate system? Or is it about how Ontario in this case or other countries are designing and implementing their measures? So this is an important question. Do WTO law and investment law provide enough policy space for countries to legislate for the climate? And it's just that, for example, in this case, maybe Ontario could have done it differently. Or is it really that they are constraining countries' ability to regulate in the public interest? Let's start with, but do you have ideas? Does anybody, we are going to go through it, but does anybody has any idea like this? Nothing? No. Yes,
I'm not sure if that was the question, but the Article 20 that we already mentioned would give some space.
So we're going to get to that. So there is, at least in the GATT, there is a provision, which is Article 20, which ideally, if you design and implement your measure properly, can give you the opportunity to legislate in the public interest. Very good. And we will see it not with this, but with another measure. We can see it with this one because the agreement on subsidies doesn't have Article 20. It doesn't have an exception. That's the tricky part. But now, in this specific case, this measure was claimed to be a subsidy. Now, the Appellate Body report in Canada Fit is one of, I think, of the most criticized reports, mostly because it doesn't really give us an answer. The Appellate Body kind of found a way not to answer. Because this was an important question, especially when this case was brought. It was a period where, there's at least 100 countries that have feed-in tariffs. It's a very popular type of support mechanism. So it was very interesting for a lot of countries to see, okay, what would be the approach of the Appellate Body? How can I design my feed-in tariffs in a way that would, survive potentially a dispute? But the Appellate Body didn't really give us much. So, as you remember, so this is kind of very refreshing. We go over the subsidies discipline again. You need to, first of all, show that the measure is a subsidy, right? So that there is a financial contribution by a government or public body and that it confers a benefit. And that if the answer is yes, then we go here. And the subsidy is either prohibited or actionable. In this case, this would be an import substitution subsidy. It's a local content requirement subsidy under Article 3 of the Agreement on Subsidies prohibited. So if the panel or Appellate Body had found that the feed-in tariff introduced by Ontario were a subsidy, it would have immediately been considered a prohibited subsidy. The problem is that the Appellate Body couldn't even tell us if it was a subsidy. It was a financial contribution, there's no doubt. Both panel and Appellate Body agreed that there was a financial contribution by a government. That was easy. The difficulty was in the benefit. So you need to show that a benefit has been conferred. If you remember, when you look at the benefit, you need to make a comparison, not between yourself and your competitors, but between yourself receiving the financial contribution and yourself without. I know that some of you don't love this, but I still think it can be helpful. So you're this guy. This is our generator guy that has obtained a contract with the grid, okay? The feed-in tariff. This of course is different, it's percentages, but in this case it was an interest rate. So you get an interest rate from the government of 3%. Is it better than if you get a loan on the private market with an interest rate of 5? Yes, it's better. It's a lower interest rate. You're the generator. You get from the government a contract of 40 years and you're paid 50. If you go on the private market, you would have gotten a 1-year contract and you would have been paid 10. Then there's a benefit. Your situation with the financial contribution is better than if you had pursued other opportunities on your own. Now here the difficulty was that you need to identify what the relevant market is. You need to identify what the relevant market is because it's within the relevant market that you have benchmarks to determine, okay, what would have been your situation if you had gone to the market and not to the government. Here's where the panel and the appellate body disagreed. The panel considered, and this is the one part where the appellate body's contribution was important. The appellate body said, well, the relevant market is the wholesale electricity market in Ontario. All of it. Wind, solar, coal, oil, we don't care. That's the relevant market. The appellate body said absolutely not. The relevant market is just the market for solar, PV, and wind. Why? Because it's not just about demand elasticity. Would you, as a purchaser, somebody who purchases electricity, would you switch? It's not important. Buys electricity. Would you switch easily? Yes. But the supplier, you are producing electricity from oil, you need to switch to wind. I'm sorry, that there's no elasticity there. So those are not the same markets. Again, this is an important statement. At the time, we were all very excited because we all started asking ourselves, what could this mean for likeness? Could this mean that then different types of energies are like or unlike? Didn't go very far. It remained in academic circles, this debate. But we were excited about that. What we were not excited about is the fact that then the appellate body basically said, okay, so the relevant market is this. We can't use the market in Ontario because this market actually didn't exist before. It was basically created by the government through this program. So the fact that the program and the government are creating a market doesn't mean that it's a subsidy, but it means that it's not an accurate benchmark. It can provide us benchmarks. It didn't exist before. So we need to find out-of-country benchmarks, proxies, similar markets elsewhere. And that's when the appellate body said, you know, you provided some examples, but they're not good enough. So the parties came up with proxies. They presented other markets that were similar to Ontario that could have been used to analyze, to do this analysis, but the appellate body said that they were not sufficient, they were not enough, and so they couldn't decide on the benefit. So it's not that there was no benefit, they weren't able to decide on the benefit. What I want you to remember about this case is simply that, well, the different steps, the importance of the relevant market, and really the important contribution here of the appellate body was to identify just wind and solar PV as the relevant market, as a market that is distinct from the rest of the electricity market. Then again, sadly, they felt that the proxies that the parties proposed were not enough. So we do not have an answer. Again, they didn't say there is no benefit. They said we can't decide. That is why it has been highly criticized. On the other hand, I have the feeling that some of the members of the appellate body were just cautious, because you make a decision, you're going to have a long list of cases in your docket based on how you're going to decide this. So this is how the appellate body decided. But the question that I have for you is, again, and if they had, let's imagine that the appellate body had found that the subsidy was a subsidy, okay? Let's imagine. It would have been prohibited. Okay, does this mean that the WTO agreement on subsidies doesn't allow countries to subsidize renewable energy? Doesn't mean that it doesn't provide policy space for countries to subsidize renewable energy? What do you think? Think about the two conditions that you had to fulfill to be eligible. what could Ontario have done differently that would have created zero problems? Yes.
Not having the LCR.
Okay. Very good. So the purpose, the climate purpose is renewable energy. So this is great. Where is it? This condition, fine. Nobody's complaining about that. Nobody's challenging that. The EU and Japan don't treat electricity. That's not the matter. The matter is the equipment. So you remove this. This is protectionist. This is not because you want to diversify your energy supply mix. This is because you want to help your domestic producers of equipment. So this goes back to the point. On the one hand, yes, and we're going to get back to that in a second. You know, there is an argument, which is an argument that I myself have been making for a long time, that some agreements, such as the subsidies agreement, could be improved. The fact that we don't have an exception, in my personal view, is wrong. You feel free to disagree. Huh? Many disagree with me. But that doesn't mean that countries cannot do anything. Again, we have more than 100 feed-in tariffs for electricity in place today in the world, and nobody's challenging them because they don't have a local content requirement, so nobody cares. Let's take a break. It's not going to get easier in the second half. This is going to be a tough session. Yes, I can see some desperation. Let's take a break, 15 minutes, relax, and then we come back and we continue. Well, there are several. But they're scientists. Yeah.
That seems very
There's two at one is so the two main ones are this one and Evelina. If you want to write it down, she's an engineer. You can just find them and say, I'm taking a class, I learned this. You just write to them. It's not the end of the semester, but you can just try to write to them, and if they have some time, they can shoot. Probably both of them. Yeah. You want to write down the names?
I remember this one, and yeah,
Tobias Brush and Evelina. You don't want to write it down?
I remember. Yes,
How can you remember it? Very hard. Yeah. Okay.
Thank you.
You're welcome. but the subsidy is going to be different. Very, very No, of course. Let me think about it. Very good. I mean, I'm sure that there's another provision of local content for parties like that. There's also the frame, so I'm sure that it sounds like it shouldn't be okay. But not because of this. Because the subsidy is not contingent. It's just that it won't be the same subsidy. So the issue maybe of discrimination. But the subsidy itself, I think it will be okay. And you should advise about that. All right. I see some of you have not come back. All right, so we are going to continue. I want to tell you now about another measure. Again, subsidies are very often used to support those low carbon sectors or green sectors. It's a way to go. But there are also many other ways, many other trade measures and policies for climate purposes that can be adopted. And one of them is this one, which you may have heard about, maybe yes, maybe not. CBAM was introduced by the EU in 2023. Carbon border adjustment mechanism. We're going to talk a little bit about that as well. It was just challenged by Russia at the WTO. This is also a climate measure, but it's very different from a subsidy. But again, it's going to help us answer the question, does WTO provide countries with sufficient policy space to pursue their climate goals? So to talk about CBAM, we need to take, first of all, I'm going to have to draw a lot. To talk about CBAM, this is me. We need to go back to 2019. 2019 is when the EU introduced the European Green Deal, which was a quite, ambitious package of policies and, regulations for, environmental and climate purposes. Here you have some of the key objectives of the European Green Deal. So, become climate neutral by 2050, very ambitious. Does anybody know what climate neutrality means? Somebody wants to say what climate neutrality means? Yes?
I think it's about compensation and not about the elimination of the emissions.
Compensation for what?
Like for the compensation of the emission that is made, there is like a contrary.
I think I know what you mean. So it's not just about having zero emissions, but it's about absorbing or offsetting those emissions. So that's what climate neutrality is. It's when the amount of emissions that you release is equal or less than the amount of emissions that you absorb or remove. And climate neutrality is not exactly the same as carbon neutrality. Carbon neutrality is only about CO2 emissions. Climate neutrality is greenhouse gas emissions more broadly. This is also, whenever you read the newspaper and countries pledge and talk about climate neutrality, that's what they mean. They don't mean zero emissions. They mean that the amount that they're going to release is going to be offset by, the emissions that are absorbed or removed. And then, of course, there is also an objective in terms of emission reduction, because you don't just keep emitting the same. The idea is I reduce my emissions, and those that are left, they will be offset. And there is a very ambitious target in terms of reduction of emissions, 55%. Now, to achieve this very ambitious target, the EU has introduced something called the Fit for 55 package, which is basically a package of a lot of different parts, all aimed at achieving this reduction of 55% of emissions. And CBAM is just one of them, just one tiny piece of the puzzle, but a very controversial one. So this is the 2019 Green Deal communication, where the EU has introduced the possibility of a CBAM. It tells you, should differences in levels of ambition worldwide persist, as the EU increases its climate ambition, the Commission will propose a carbon border adjustment mechanism for selected sectors to reduce the risk of carbon leakage. First of all, differences in levels of ambition worldwide will always persist. We go back to what we said earlier about climate framework. We will never expect all countries to be ambitious in the same way. We can't, again, remember the principle of common but differentiated responsibilities. Countries have different responsibilities, they have different capacities, they will not have the same level of ambition, and even if they do, or even for those that do, they will not try to achieve that level in the same way. You know, the EU loves cap and trade. Some other countries might want to do other things to reduce emissions. So this is not about should, this will persist always and forever. For selected sectors to reduce the risk of carbon leakage. Now, to understand this issue of carbon leakage, I need to tell you a little bit, bear with me, about the ETS. Is everybody aware of the EU ETS, emission trading system? Okay. So, again, countries can choose what kind of measures they want to reduce emissions. The EU has, among other things, has introduced years ago what we call a cap and trade system. Cap and trade. What does it mean? That it's a way of pricing carbon. There is not a carbon tax. A carbon tax, the government taxes carbon and says, you emit, I'm going to charge you $50 per ton. I decide, the government. Voila, carbon tax. Some countries do that. Cap and trade, different. You put a cap on all emissions. So the EU has identified some sectors, high emitting sectors. They have set a cap. So our total emissions is going to be X, the emissions that we allow from these sectors. How do we reflect this cap? With allowances. We are going to produce a number of allowances that gets up until this level. If you are in one of the sectors covered by the ETS and you are going to emit, you need to buy allowances. 1 allowance per ton of carbon dioxide equivalent. You know you're going to emit 10 tons, you're going to buy 10 allowances. So you need to purchase allowances, the number of allowances has to reflect how much you emit. You end up emitting less, emitting more, you can trade. You end up emitting only 8 tons, you have 2 extras, you can sell them. So these allowances are traded between companies. So the price is not given by the government. The price is given by the market. And I checked yesterday, this is the price as of yesterday. 81.980 euro per ton. So if there is a company that emits this much, it's okay as long as it has bought this from a company that is emitting less. What matters is the cap. Now the EU wants to reduce emissions. So this cap is going to be lowered with the years. One fear of the European Union when they introduced the ETS was carbon leakage. You know, we have carbon leakage is when a company, instead of staying in the EU, goes to another country where there is no carbon price, not to pay for their emissions. Climate change is a global problem. Who cares where you're emitting? You need to not emit. So you take all the steel companies in the EU, they all go to Indonesia, because let's imagine there is no carbon price. We don't fight climate change. And European companies suffer, because if those Indonesian companies sell back their products to Europe, European companies, they don't compete because they're paying all that carbon price, so their products will be more expensive. That's the risk, right? That you have the EU, where you have that to pay, and then you have a bunch of other countries that maybe do not have a carbon price. I am a steel producer, high emitting sector. I'm going to go here, produce my steel, pay nothing, and then I'll sell it back to the EU. So initially, to avoid this problem, what the EU did was to give free allowances to producers in some critical sectors, high emitting, to keep them in-house. Steel, iron, aluminum, however you prefer, fertilizers, chemicals, high emitting sector, cement, free allowances. That went on for years. And again, I give you free allowances so that you don't have to pay the price and you don't relocate. But it kind of makes the system not work so well, because these are the highest emitting sector. The price also doesn't really reflect what it should be, because you have all those free allowances. So what the EU has decided to do is to phase out the free allowances, meaning producers in these sectors, cement, iron and steel, aluminum, fertilizers, from now on you have to pay like the others for your allowances. So the risk of carbon leakage is back. That's why they've introduced CBAM, a new way to deal with carbon leakage. There is a climate element, but there is also, of course, an industrial element. You also want to protect, and it makes sense, the competitiveness of European industries. And how does it work? Why does it prevent carbon leakage? Because the idea is to level the playing field. I'm gonna use 100, because if I have to make calculation with 81.9, we're gonna stay here for 25 hours. So let's imagine that the price for 1 ton is 100, okay? Let's imagine, just because I can barely make calculations with these numbers. You are a steel producer in the EU under the ETS. For every ton of carbon dioxide equivalent, you need to pay 100 euros. Easy. CBAM, it's an adjustment. It's a charge that is imposed on imports based on the carbon embedded in the product. How much have you emitted producing the product equivalent to the ETS? I'll show you with an example. Let's imagine that this is country A, country B, country C. Country A, there is no price on carbon, no price. You are a steel producer from country A, you pay 0 for how much you emit. You want to sell in the EU. CBAM. What is the carbon content, the embedded carbon? You have emitted 4 tons. Perfect. 100 per ton, you pay 400. Just like domestic steel producers. A domestic steel producer that emits 4 tons also pays 400. So this one emits 4. This one also doesn't pay anything. There is no price. But this one emits only 2 tons. How much do you have to pay in your adjustment? 200. Good. This country has a carbon price, but it's not, it's lower. It's 40 euros per ton. You produce steel, you emit, again, let's say 2 tons. You will not have to pay the full adjustment.
120.
What? Super fast. Who did it?
120.
I actually don't know if that's correct, because I'm so slow, but it would be 100 minus 4, 120, very good, yes. So you deduct what you're paying from, so you adjust, because the idea is that, and again, this is gonna go when we talk about, this is supposed to be, according to the EU, this is an internal tax. It's not an import tariff, according to the EU, because it's an internal tax. It's like, it's the EU ETS, basically, adjusted. So you don't pay anything. Your adjustment is that you have to pay the same bless you tax that is paid by European companies. You pay a little bit, but less. It's adjusted. So you will still have to pay something once you enter, but it's adjusted. It's not the full price. And then there are countries like Switzerland. Switzerland has its own ETS, which is linked to the one of the EU, same price, you don't have to pay anything. Norway, Liechtenstein, there are a few countries that are attached to the EU ETS, or Switzerland that has its own, but it is linked with the same price, so then you don't need any adjustment. So then you have a steel producer in Switzerland that sells to the EU, you emit 2, you don't have to pay anything, because you already paid back home. That's the idea. And the idea is to prevent carbon leakage, because whatever EU companies pay, the others end up paying the same if they want to export to the EU. And you level the playing field, so the European companies don't suffer that much. Is this clear? And only for selected sectors, only those sectors that I mentioned, cement, iron, steel, aluminum, fertilizers, chemicals, that were initially had the free allowances and that now don't have them anymore, for which the risk of carbon leakage is especially high because they are super high emitting. And then they say, oh, don't worry, this measure will be designed to comply with the World Trade Organization and other international rules and other international obligations of the EU. Well, let's see about that. And by the way, it's very interesting, these other international obligations of the EU gives you an idea that, for instance, climate obligations as well. And we will see about that. So if you think about your piece of steel that comes from a country where there is no carbon price, that emits 4 and has to pay 400. This one also, there is no carbon price, but this one emits 2, so it has to pay 200. This one has a carbon price, emits 2, and you have to pay 120. This one emits, let's say, 6. You have to pay 0. Who cares? Because you're paying already. You're linked to the ATS. Do you see any problems from a WTO law perspective? Think about the GATT. Do you see any problems? What do you think? I mean, Russia has raised everything because you try everything. But what do you think could be a possible argument? MFN, why?
Because the foreign investors have to pay different prices to enter the market, disregarding the fact, like, if I have to pay at home 40 and to enter 120, I still have to pay less than the one that paid 200. like, I don't care if they paid 40 in their home country, I don't produce there. So the other foreign investor has a better treatment than I have.
Okay, and what about the carbon content? For example, these two are paying differently. It's the same piece of steel. They pay differently because they have emitted differently. Would this be an issue under MFN? Are the two products like? Yes. So a lot of MFN problem, because you have all these different prices based on things that have no bearing on the physical characteristics of the products. So definitely MFN. What else? Hmm? No discrimination, very good. I don't know who said it, somebody in the back? You? Exactly, so again, the EU is framing this as an internal tax because they're saying that this is the ETS, it's just an adjustment on the ETS. It's not an additional import tariff. EU companies also have to pay it, it's just that they pay it under the ETS. And so they're arguing that it's an internal tax. If it is, you have the same issue with the likeness and the non-discrimination. So there's an element there. There are a lot of regulatory aspects linked to CBAM, certificates, so it could also be an internal regulation. So you have 3234. A lot of countries are arguing that it's a tariff and there is a violation of Article 2. So, I mean, I'm curious to see the first case, just to the determination. I see it as an internal tax and regulation, but let's see what the panel says. But all of these are very good points. So there's a lot of room for violation. And then what one of you mentioned earlier, Article 20. And that's where my question is. Do you feel that because of how PPMs, and you can have your own opinion, this is not something that I'm expecting a specific answer, but do you feel that because of how PPMs are interpreted, so the fact that how much you emit doesn't really matter, and the products are going to be like, is this something that would block a country from adopting a climate measure like CBAM? Or do you think that it's not a big deal and it's better to go through Article 20? I mean, I have my view, but do you think that these products should not be like, and therefore there should be no violation of MFN? Nobody has strong opinions about it. I personally don't think, I think that it's okay. And that's not because I'm not sensitive to environmental concerns. I work in this space. But if we allow PPMs to come in the definition of likeness, we're basically saying CBAM doesn't violate anything. And it's okay to keep it as it is. Now, if instead we keep likeness to the 4 criteria, that doesn't mean the EU has to remove CBAM. It's not the end of the story. We have Article 20. And Article 20 is there because it provides checks and balances. It helps us understand and filter whether a measure is really, really genuinely trying to pursue policy goals, legitimate policy goals, or whether there is some hidden protectionism. If we allow the difference in carbon content to get into the likeness analysis, we lose this opportunity to check for hidden protectionism, which I think it's a good thing that we have this filter. And then we go to Article 20. And here, I want you to think carefully back to my favorite case, which everybody knows which one it is. There you go. So the chapeau, do you remember why the US lost under the chapeau? What didn't they do, or what did they do that was not good?
They did not consider other measures apart from, I don't know the name, to say, to fish the shrimps without.
Very good. What is CBAM doing? In order to pay less or not pay, you need to have a direct carbon price. But what if you have other things? Now, the fact that these two countries don't have a direct carbon pricing mechanism, it doesn't mean that they don't have measures to incentivize their companies to emit less. Not all countries have the capability, the possibility, politically, economically, to introduce a carbon price, a carbon tax, a cap and trade system. You are telling countries that they have to do like you. So the fact, and there is a reference, between countries where the same conditions prevail, you're not even making distinctions whether some of these countries might be extremely poor. So very rigid. We will see what, I do feel that some violations is going to be found. We will go to 20, it's going to be interesting. I don't think it's going to be hard to go through the paragraphs. Article G in particular, gasoline, has told us, US gasoline, that protection of air quality is climate change with pulp mills, it's fine. So it's going to go smoothly, probably, through the paragraphs. But the chapeau, there is an argument to be made that you are not taking into account what the other country is doing. What you really want, you want other countries to impose the same measure as you. So let's imagine that the panel reasons like me. Let's imagine. Would that mean that CBAM is wrong? No. CBAM makes sense conceptually. It does make sense because you address carbon leakage, you level the playing field, you increase competitiveness. That makes, but how you design it and implement it. There are so many choices that you make when you're designing and implementing a measure like CBAM. Which sectors do you cover? How do you calculate the carbon content? Which policies of the other country do you credit? Only carbon prices, or do you want to be broader? How do you use your revenues? There's a lot of choices. So, and even if the EU were to lose, they wouldn't have to remove CBAM, they would just have to make adjustments and modifications to make sure that it complies. This is just to tell you from someone that is working for many years on the reform of WTO law that it doesn't mean that it doesn't allow countries to pursue climate policies. It does, but you need to be careful as to how you design and implement those policies. Everything clear? Okay. What about investment law? This is a little bit trickier. Here I have a little bit less faith, personally. Meaning that, yes, of course, there's a lot that we can learn from the case law. Sometimes the problem is not so much that you are phasing out, or you are shutting down, a gas field, but how you do it. So you may adopt measures in a way that doesn't, upset foreign investors, but the issue of regulatory chill is real. Countries are frozen, are afraid of disputes. And it's not just because, I'll show you some statistics, but it's not just because they're losing disputes, but even just the fear that there may be a dispute is enough. And yes, we have had, we saw some cases, I show you in the, when we talked about national treatment, for example, MFN, in investment law, I talked to you about the Parkerings Lithuania case, the one with the parking structure in the old town of Vilnius, and I showed you how the tribunal interpreted with an environmentally friendly, in an environmentally friendly way, the term in like circumstances. So this is not to say that there isn't a jurisprudence or some tribunals that have been very open. But in my view, that is not enough. The regulatory chill is real. And just to give you a few statistics, the most litigious economic sectors, energy, mining, so those are key sectors where countries intervene for climate change purposes. And you see, it's really the vast majority of the disputes. And then if you look at the outcome, this is general, both jurisdiction and merits. You see that there's a good percentage of cases that are decided in favor of the investor, Also some, a lower percentage of the state, but then there are, again, some are settled. But, you know, as a state, you don't love these either, because while you're settling, maybe, you know, you can keep your measure up, and so on and so forth. And for those that are decided on the merits, I mean, overwhelming majority in favor of the investor. So you're a state, you're like, I'm sorry, but I mean, I don't want to get into this. So the regulatory chill is a real issue. Countries are worried, and they are frozen as to, you know, what measures they can adopt. And this is just to give you an idea, the IPCC, this is the latest assessment report of the IPCC of Working Group 3 that works on mitigation. And it tells you, it tells you one aspect, the development of legal norms. A large number of bilateral and multilateral agreements, including the Energy Charter Treaty, include provisions for using a system of ISDS, decide to protect the interests of investors in energy projects. Numerous scholars have pointed out that is used by companies to block national legislation. You have a scientific body that writes about this, because this can be seen as an obstacle. The existence of investor-state dispute settlement, the existence of these provisions, the fact that a lot of the standards are interpreted broadly. And you know, investment treaties, they protect investments. All investments, even bad ones. Even those that are bad for the environment, even those that are bad for climate, they're protected, they're investments. Once you fit into the definition, and by the way, this is the same issue that I have with the subsidies agreement. Whether you're subsidizing renewable energy or fossil fuels, you get the same treatment. No distinction. And this takes me to the last point. And if we don't finish, we won't, but we can, actually it's second to last. We will continue next week. So there is a certain extent of maneuver that states have within the existing framework, and also that's what states have to do when they're legislating. You know, they need to, the rules are there, so they have to know them, understand them, and design and implement measures keeping in mind that this legal framework exists. And in particular, I think when it comes to investment, it's trickier, but when it comes to trade, there is room. So countries, depending on how they design and implement their policies, they can, for example, they can subsidize renewable energy. The Canada FIT case is a good example. That case doesn't tell us that countries can subsidize renewable energy. What it tells us is that they can't be protectionist while they do so. So don't use a local content requirement, or you're going to get into trouble. But it doesn't mean that you don't, that you can subsidize renewable energy. But, and this is where I personally have an issue with, is that just as it allows countries to subsidize renewable energy, it allows them to subsidize fossil fuels. And we have had, we don't have any agreement. The Paris Agreement doesn't say anything about fossil fuels. We have several decisions of climate COPs, of the Conference of the Parties, Glasgow 2026, the one in Dubai in 2026, sorry, that was the 26th, which was in 2021. 2023 Dubai also, the decision of the COP talked about transitioning away from fossil fuels, phasing out fossil fuel subsidies. So there are calls for countries to phase out fossil fuel subsidies. So some proposals in terms of reforming subsidies rules are not so much that there should be more space for countries to subsidize renewable energy, but that there should be some rules that do not equally allow to subsidize fossil fuel subsidies. Because if you introduce some level of prohibition for certain environmentally harmful subsidies, with some caution for countries that heavily depend on fossil fuels, then you incentivize countries to repurpose those subsidies to other sectors, ideally low carbon sectors. And this is, again, an argument that you will find, an argument that I have been making. together with a former professor of mine, colleague now, we have been every other day to the WTO, try to convince members that this is the way to go. It's not working so well, but we keep going. But this, for example, is an idea of what, according to us, is wrong with the existing disciplines. Again, it's not that they don't give you space to subsidize good stuff, but because they also allow subsidizing the bad stuff, you have no incentive to switch. And subsidies to fossil fuels are still super high, much higher than renewable energy. So our proposal is to basically create different boxes. Right now, the subsidies disciplines is really based on the trade impact. A lot of trade impact, export subsidies, local content requirement, prohibited, less trade impact, actionable. That's it. Instead, what we propose is to start, is to look at the impact on, or the relevance from a sustainable development or environmental perspective. And then, in a second moment, to look at the distortion of trade. So ideally, if you are, again, I won't be asking you about this in the exam. I just want you to know, again, this is part of a broader debate on reform of WTO rules that we've been working on. I mean, I'm not alone in this, but just for you to get a sense of the kind of debates that are out there, and then you can make your own opinion. You can also, again, think that this is not a good idea. So first, you look at what is the impact from a sustainable development perspective. If it's good and it's not very trade distortive, it's automatically allowed. Otherwise, there is a rebuttable presumption of consistency. So if it's highly distortive, there is a presumption of consistency that can be rebutted, but the burden of proof is on the other party. So it's not like an exception. And there are different tests, proportionality and so on and so forth. If instead it's bad for sustainable development, but not very trade distortive, it's provisionally inconsistent unless you can show, for example, that it's fundamental in your country, that it's particularly important, your economy, whatever. But if it's very trade distorted, then it's absolutely prohibited. This is just a way to, again, there's many ways to do this, but to introduce some level of distinction based on the rationale of the subsidy. And then it's an argument, and you can, I talk to a lot of trade lawyers that agree that the rationale of the subsidy should play a role in the discipline, and others that say it doesn't matter, it's just about trade impact. Fair enough. Now, an example of something that has actually happened is this one. The ACCTS, the Agreement on Climate Change, Trade and Sustainability, which is between Switzerland, New Zealand, Costa Rica, I want to say Iceland. Yes. So it's 4 countries, very recent. And what's interesting about this agreement is that it's the first one that prohibits fossil fuel subsidies. Just prohibits them. It singles out what they are, and then it prohibits them among those countries. So this is another way. What we had proposed, what we are still proposing, is to have a broader framework covering both industrial and agricultural subsidies, not singling out specific sectors, because if you go to the WTO and you propose an agreement against fossil fuel subsidies, you will never get it out, because you have fossil fuel producers that are going to block it. Consensus, I remember. But if you propose ideally something broader, even not just about climate or environment, because that's also not good, but it's about sustainable development, with all the challenges that defining sustainable development entails, then you might gain more traction in terms of more membership. But this is another way. This is a regional agreement, so it's only 4 countries, like-minded countries. We will talk more about these different approaches, regionalism, bilateralism, vis-a-vis multilateralism next week. But it's interesting. First time that we have trade disciplines on banning outright fossil fuel subsidies. Well, in 2 minutes, I'm not sure what I can do. Let's do this. Let's stop here. There's no point in starting investment and stopping. I think I have maybe 15 minutes left, which I'll take next week. And then it's okay because it's kind of linked anyway to this discussion on geopolitics as well, because a lot of the challenges we'll see next week also have to do with these climate measures. It's not just about that, but it's also about that. Any last minute question regarding today's session or anything else? Nate? Yeah?
You were saying that for investment law, you see less policy space. Do you feel like this could change? And what would be needed?
That's what we're going to talk about here. So one way is hoping that the arbitrators will look at climate, but unpredictable. The other one is changing the rules, and we'll talk about it next week.